All right, hello and welcome everybody. Thank you for joining us this evening for the Protect Your Family Tree with Estate Planning event. As an attorney, Debra Anthony helps people arrange smooth transitions without court. People sleep better knowing their affairs are in order, and so she focuses on estate planning like wills, trusts, and beneficiary designations. She started her career working for federal courts, state Supreme Court, and a branch of the United States Supreme Court. She loves helping people understand estate planning, and we are very grateful to have her join us today. Thank you so much, Debra.
I'm happy to be with you. Are we all set with the technology?
We're good to go.
All right. Well, welcome everyone. And start with, I love taking pictures, and we're going to start with, if I can work the technology. Help me out here. Maybe by moving it,
I wonder.
There we go. There's a picture I took on the boundary with between Minnesota and Canada, sort of near the boundary waters. The yellow along the edge is wild rice. And then my husband and I were out there by ourselves in a boat, and we didn't know that there was going to be a big storm. But fortunately, we had our raincoat in a backpack. And then after the big storm, driving rain, huddled under our raincoats, the rainbow came out, and I took a picture, and I just enjoyed the picture for a few years. And then one morning I was waking up and I realized having your estate planning in place is like having your raincoat because you don't know when there might be a car accident or something. And I think that a place to start with estate planning is the healthcare power of attorney. That is a form. I gave copies of it for you back there, and for people online, if you want it, just let us know and we can get it to you. You may already have one. They hand these out at hospitals. Illinois has a healthcare power of attorney, and in it you can say, this is my name, this is my address, and if I'm unconscious, if I can't talk, here's who I would want to talk to the doctor for me. Your first choice, your second choice, your third choice, as many choices as you want. And I think that is the place to start. And I also think anyone 18 and older who has their right mind needs a healthcare power of attorney if they have someone to trust. Some people don't have anyone to trust. And then if that's your situation, we could talk about other options for that. But if there's someone you would trust, like, for example, if I'm in a car accident, I break my arm and I'm unconscious for a few days, I'm going to be fine. But they want to talk about different ways they could fix this broken arm. Who are they going to talk to while I'm unconscious? Who do I want them to talk to? So that's the way to think about it. And so I gave, and just in case you don't have a healthcare power, I brought a stack of them there. And if you know anyone 18 or older, I recommend everybody in the state of Illinois 18 or older. I've had parties with 18-year-olds where they're all filling them out and their parents are there and they're passing them around because you have to be 18 to be a witness. So anyway, I think healthcare power is one place to start. What do we need to do here?
Oh my gosh, you guys, I'm sorry. The technology sometimes does not want to play nice.
And then I'm getting like a poll.
Oh, okay. Yeah, that was meant for me. I don't know why you're getting it.
Okay, that's right. I won't look at it.
Well, you can look at it. It's how many people are watching.
Okay.
We like to get accurate numbers from online.
Okay.
Sorry, folks online. We've got a tech problem in the room, but we're dealing with it. And we are. It happened earlier.
Okay.
It's just, I will fix it.
Does anyone have anything you want to say about a healthcare power while we're fixing technology? Is it all pretty clear? Okay, for people who might have come in after we started, there's some handouts and I like to take pictures. There's a free greeting card you can take.
It's literally.
Do you think it's out of battery or something?
It shouldn't be because the battery shouldn't have anything to do. It's just like.
So we're seeing it here on this computer.
Yeah.
I can do it without slides.
Well, no, I mean, yes, if it comes to that, but give me one, let me try one thing.
Okay.
Sorry, everybody. It's always something.
I'll tell a little story. I started coming to this library when it was in the old building in '83. I had been an attorney already, and we were recently coming back to Illinois, and I needed to study for the bar exam. So I was in a little cubicle every day for hours and hours. And I had a little boy in first grade. When he got off the bus, he rode his bike over here and looked in the children's section. And so the head librarian asked me to be on the library board because I was at the library every day. I'm like, I'm sorry, I can't fit it into my life. I'm here because I have to study. So, and I think I'm the only person who's taken the bar exam who really enjoyed the process.
You might be the only person in the world.
I went to law school. I went to undergrad at the University of Illinois, Champaign. And then I went to law school at the University of Wisconsin, Madison. And before that, I thought I was finished with my career. So I worked for a year and I became a Wisconsin resident without trying. In any case, that's good for when you go to school because you get better rates. And the other thing is, I didn't know, is if you're a Wisconsin resident and you graduate from a Wisconsin law school, and there's only two, with a certain grade point average, and you take all these required classes, you don't have to take the bar exam. So they're one of two states. And so I had been an attorney for 5 years before we came to Illinois, but I needed to take the Illinois bar. So I already knew something. I already had practice in law. But I loved studying for the bar exam because in that process, you study every subject. And I could see the trunk of the tree from which all these branches came. And that was really exciting to me. But for most people, I feel like, no, we're not so thrilled about this bar exam, but I'm just kind of person who likes to see how it all kind of fits together and comes together. So that was a little,
Yeah, a little
unexpected aside there.
If you try the clicker again, let's see if it's gonna do what it's supposed to do.
I could do this.
Yeah, it's not a touch screen, but if you move the mouse and click
Okay.
right there. and
Yeah,
then-
once you get used to a touch screen,
I know. this
you're
is-
stuck with it. Okay. Are ready to move forward? We all set? Okay, this is a really important slide. We're back to the program now. To avoid the probate court process, every account that's not owned in a trust needs a beneficiary, including bank accounts. And beneficiaries can be individuals, charities, or a trust. So just to think about a person who's starting out, like maybe 25 years old, they take their first job and the job comes with life insurance or 401k, they need to put a beneficiary on that. They might not be married at that time. They might not have a child by that time. So maybe they put their sister, their brother, their mother, their father. And then as time goes by, hopefully that person lives till they're 100. But as time goes by, they might get other people besides their parents or their siblings that they want to name as beneficiaries. So every asset needs a beneficiary unless it's going to be owned by a trust. And we're going to talk about trusts a little bit later. And one of the main types of assets that gets forgotten are bank accounts, because the banks don't ask most people. Most banks don't ask anybody. Who would you like to be the beneficiary of this? And if it's a joint account, like if you're married and you have a joint account with your spouse, at some point you could both pass away, and who do you want it to go to? And if you had a trust set up, it could go to the trust, and then the trust says who to give it to, or it could be individuals, it could be charities.
I'm sorry to interrupt you again. There's another tech problem with the way we're sharing the screen, and
Okay,
let me just quickly fix it. And then
Sure.
we really will be fine after that.
okay. So is that principle pretty clear? It's really important because so many times somebody passed away and then we've got a bank account out there without a beneficiary. And so the probate court process it's a nice little process, but it usually costs at least $5,000 and takes a year or so. So it's unnecessary in almost everyone's situation. Now, if someone passed away, let's say someone named Joe passed away, and we look around and we say, oh, he had a beneficiary or trust on everything, but he had this little bank account over here or this little something over here. He didn't have a beneficiary on. If let's say there's 5,000 there and 3,000 there, if the total of these things without a beneficiary is 100,000 or less, there's an alternate process in Illinois. But if he owed taxes, or maybe he hadn't been sending in tax returns, anyone who signed this alternate process is now responsible for owing the IRS. So it's called an affidavit. It's a dangerous affidavit to sign if the person who died might owe somebody. And let's say my aunt dies and I go into the bank and I sign for her $20,000. Well, it's not for me. I'm supposed to get it to who it belongs to. And that's what I'm signing on that affidavit. I'm going to get it to who it belongs to, including if she owed some credit cards or she owed whatever. And if she had various, cousins that are equal to me. So we like to have beneficiary designations on everything. Okay. All right. Now, do I try clicker or I just touch this?
Press it with the mouse, I think.
Okay, we'll do the mouse. All right, wonderful. Okay, here's a little picture, an ancient picture about the probate process, where if someone had a will, they would examine it. Now, the things that go to probate are things without a beneficiary that are owned by the person who died. They're solely owned by that person who died. And they don't have a beneficiary. Okay, with or without a will, we're talking about probate. Now, I gave you, later when you leave, if you read through the green sheet I gave you, you'll see that some of what I'm saying is written there. All right, so these are some of the ideas that come here. So for example, I didn't help this man before he died, but I got involved after he died. He saw an attorney who wrote a will when this man actually needed something better than that. But this man never had any siblings. His parents were gone. He didn't have any descendants, no spouse. And so the attorneys who had to help with the probate process had to do a whole genealogy search to figure out who are his closest relatives. So you're paying all this money in unnecessary ways. And his will didn't give any of it to those people. His will gave some to this one person and the rest to charity. There was a much easier way the attorney could have done that without having to have an attorney spend eons trying to figure out who in the world are his closest relatives so we can get them all to sign a form and tell them you're not getting a penny, but we can't proceed unless you sign this form. So it can be it's not like the attorneys are trying to put in a lot of hours necessarily. It's a process that's supposed to be fair. And if a person doesn't set it up ahead of time, then it's a problem. Okay, but we're here to talk about how to do it right. Here's an example of the woman in the blue shirt. Like this is like the one who's left when someone dies and goes, what in the world do I do? And here's another thing about probate. We're not going to worry. We know we're going to try to stay away from here. Now, here is what we love, beneficiary designation. If the person who died was the sole owner and it has a beneficiary designation, shoop, it goes to those beneficiaries. And all it takes is a death certificate and we're done. Doesn't that sound good? Okay. Now, I keep thinking it's a touch screen. All right. Here's my little superhero, the power of one line beneficiary. You get to choose. It could be individuals, it could be charities or trusts. Now, individuals could be people like a spouse, a friend, children, so forth. We'll talk a little bit more about that. Charities, y'all know what charities are, and then trusts we're going to get to in a little bit. Here are the main estate documents a person would want. There are two power of attorney forms. One is for health, that's what I gave you a copy of. These are in the state statute. And the other one is called property, but it applies to finances. And that is a somewhat similar form where you say, this is my name and if you couldn't think straight and somebody needed to pay your bills, who would you want? Who do you trust? Is there anyone trustworthy to put on that? And you can list as many people as you want in order, but only one person can serve at a time on these forms. And the power of attorney for property is only in effect during your life. So for example, my mother named me. She was in another state. We had to work with a different attorney. But when she did this work, she named me as the person who is responsible in all these different forms. On the power of attorney form, we call it agent. We're going to talk about a trust. In that form, you call it trustee. So on the moment she took her last breath, I have no more power on the power of attorney. The agent has no more power. And so if that power of attorney for property applies to assets in her name individually, not in trust. And so if she has a bank account in her individual name and I'm at the funeral home trying to pay the bill, I can't take money from there today. I don't have a death certificate yet. So, but I can take money from the trust because the trust can continue after death. So it's really important to know that the power of attorney for property, the power ends, we call the person who signs it, like in that case, my mother, she's the principal, spelled like a principal at a school. She's the principal. And then the person she names is the agent. It's kind of like an employee in a way. Employees are agents of their employer. So, but she doesn't have to pay me. In any case, when the principal dies, the agent has no power on a power of attorney for property. But with a trust, which we're going to get to, that power can continue. It can be during life and after death. And one thing that's important to know is qualified retirement plans like IRAs, 401ks, those have to stay in the individual's name during life. So if my mother had an IRA, she couldn't put it in her trust during life. So that power of attorney for property is going to apply to that IRA or that 401k. If, so example, she was sick in December and she hadn't taken her required minimum distribution and we need to get it out, she would need me to help her with that. So we almost always need a power of attorney, at least for the qualified retirement plan, like an IRA, 401k. And if someone doesn't have any human being that's trustworthy, who's not going to steal from them, there are professionals and there are trust companies who will help with some of these roles. All right, the next bullet point here is will. And we talked before that with or without a will, something in a person's name alone without a beneficiary is headed to probate court. If a person needs to go to probate court, it's better to go with a will than without. But when I work with people, we try to have nothing go through the will. And the way we don't have anything go through the will is we have beneficiaries on everything, either owned by the trust or beneficiaries on it. And the trust could be a beneficiary. Okay. So the trusts are for some situations. We are headed that direction as soon as I learn to push the right button here. Okay. Once you get used to a touch screen, you just think it is. All right. Has anyone ever heard this term in Latin? Per stirpes? This is important on beneficiary designations. So per means by, and stirpes means branches. So per stirpes means by the family tree. So if, let's say, Sally is trying to fill out a beneficiary designation and she wants to leave it to her 3 children, one thing she needs to think about is, well, it's possible that by the time I die, one of my children might have died. And if I have some grandchildren, do I want, like if I have 3 children, do I want that, if one of my children died, do I want that 1/3 share to go down to their children? Most people would want that if they think they might have grandchildren. Now, if it's Hannah over here and doesn't have any children, she's not married, no spouse, she wants to give things to, say, cousins or friends, she might say, no, if I have 3 friends, if one dies, just forget that person. You know, I don't want it to go to their children. She might or might not. So if it doesn't go down and it's just the ones who remain, the Latin term for that is per capita. Capita means head. So by the heads of those who are still alive. So as people, if you're naming beneficiaries directly on a beneficiary form, please, especially if you have children, think about if you would want it to go down. Now, people who are married often want to say first my spouse and then either my children or a trust for my children. But not everyone has a spouse or children, so everyone's different. Any questions so far? I'm going to show you a picture of purse derbies next.
I did have a question from Zoom. They asked, can you designate a beneficiary even for property?
Like real estate?
Yeah.
Very good. We're going to get to real estate. That is a special topic. And I'm thinking about the slide after this. We're going to talk about that. Okay, so here's a little picture of purse derbies. So you can see on the left, if you are at the top there and the child on the left passed away before you and had 2 children, would you want that child's 50% share to go down? See how that works? Now, if you didn't want that, you say, well, no, I don't want anything to go to grandchildren, or maybe you don't have children, you're leaving it to friends or cousins or nieces, nephews, or whatever. And you say, I like my nieces and nephews. I never met their kids. I don't want to leave anything to them. So then you're going per capita. That's what's on the right. So that if one dies, that side, that line gets nothing and the other side gets everything. There was a sad story I heard of a man who had 2 sons who were adults. And when the form was being filled out, he didn't know to check the box for purse derbies. He did really mean it if anybody had asked him, but he didn't check it. And then one of his sons who had little kids was in the same hospital as the father on the same day. And the son died 10 minutes before the father. So then everything went to the other son and nothing to these little kids who now lost a father and really needed money. So this can be really serious to think about. And usually people have children, want it to go on down, and people who have who don't have children often have differences of opinion. I've written some documents for people without children where they say, okay, I've got these 4 friends, these 2, if they die, I want it to go down. These 2, if they die, don't want it to go down. So that's in a trust. In a trust, you can write as many pages as you need to, but on a beneficiary form, you can't. In that situation where that man had that thing, then the trust would be the beneficiary. Then when it gets to the trust, we can write as many paragraphs and pages as we want to say, if then there's the blah, blah, blah. Okay, are we okay with purse derbies right now? Okay with beneficiaries? All right, let's go to residences now. So I have a slide about here. So here is a residence owned by a single person. Okay, isn't he cute? Now, it depends what the person wants. Who does the person want to leave the residence to? So we have options. But we don't have just a little beneficiary form like you get for your IRA. Okay. One option is he could leave it to a trust, and then the trust could say what to do with it. And there are real estate forms that we fill out to quote, leave it to a trust. We can either have a deed to a trust now in 2022, or we can have something called a transfer on death instrument that says, if I own this when I die, then I want it to go to blank. And blank could be a trust with all sorts of provisions, or blank could be, you know, my friend so-and-so. Now, if a person has children, it would be best to leave it to a trust. If a person only has 1 child, let's say a person maybe never had a spouse, or at the moment doesn't have a spouse, and they only have 1 child, we could leave that transfer on death instrument to 1 child. But if, say they have 4 children, it has to be left equally. And then if you leave it to 4 children outright like that, now you have 4 owners of this property. It gets to be sort of complicated. It'd be easier to put it to a trust and have a trustee and then let each of the children get an equal share. Okay, so real estate is a special type of asset, and it needs documents that get recorded with the recorder of deeds. So even if we do a transfer on death instrument today for this man, we need to record it because the rules of Illinois say we're not going to honor it when he dies unless it's recorded while he's alive. And it also allows you to change your mind, allows him to sell it. He could sell it if he didn't want it after a while, but so that's one thing. Now we're going to go to residences owned by a married couple. Now, often a married couple owns a residence together, and their intent is that if one dies, the other one fully owns it. So in Illinois, later, when you have time to read my little 1-page handout, I'll explain in there that Illinois has a special law. It's a great law that allows for some asset protection for that residence while it's owned by the two. So we don't really want to move it to a trust in 2022 while they're both still alive. But we could do those transfer on death instruments for each of them, that each one has a paragraph that says, upon my death, if I'm the last owner of this property, convey it to probably a trust. If they only had one child, maybe convey it to our son so-and-so or our daughter so-and-so. So married couples have a special law in Illinois that helps with asset protection. And so we have to kind of consider a lot of different laws when we're thinking of planning. Does the person who asked the question about real estate have anything else they want to say right now, or should we talk about trusts and then come back to that?
She didn't have another real estate question, but she did have a purse derbies question. Do you want me to hold?
Sure, no, let's go back to purse derbies.
She was asking for purse derbies designation. If child 1 doesn't have kids, then what would happen? Everything would go to the second child.
Right. Okay. And the other thing about purse derbies is like this is one of the first things, at least as far as I understand in my experience, that we learn in law school. Like almost any attorney, even if they're not doing this area of law, would probably have heard of purse derbies. We haven't figured out how to say this in English, but it means by the family tree. So it could cover, like I have an aunt who by the time she passed away, there were like 5 generations under her that were already born because people had children young in each generation. So purse derbies could cover if, you lost a few generations. It can keep going down until we find somebody under that branch of the tree. That by saying purse derbies, it covers paragraphs that we otherwise might have to write. So often when I'm writing a trust for people who do have children and want purse derbies, we say, leave it to my descendants purse derbies. And so in just a few words, we can cover all sorts of things that might happen because none of us quite know. I'm especially aware of car accidents. We just kind of never know how life is going to go and who's going to be alive when this person passes. If there's any follow-up question, please ask me. But like, for example, the people I help range from like age 32 to 102. If I'm dealing with 32-year-olds who have a baby, they're still going to say purse derbies, but they're hoping that they live to 95 and their children live to 95. But, you don't have to know if you're going to have grandkids. But if you're never going to have kids and you're never having grandkids, then, it's not going to make a big difference whether you say purse derbies. Okay. Let's talk about trust. Whoops, it's going a little fast on me. Here we go. I'm going to try to get control of this. Let's see. Here we go. So I hope it'll hold still there. All right. Here's a trust is invisible. It's a relationship. It came about 100 years ago when in England, you had two landowners and one is going off to war. And he says to his neighbor, I trust you. That's how you came up with this concept of trust. I trust you. You're the trustee to take care of my land while I'm gone. It's still mine. When I come back, it's mine, but I trust you to take care of it. So trust is a relationship, and it's sort of invisible. Most trusts that are started nowadays in the US, the person who starts it is the trustee. So if Lizzie started a trust, it'd be Lizzie as trustee of Lizzie's trust. You know, if I started, it would be Debra as trustee of Debra's trust. So it's these days, it's usually the person who starts it is the trustee. And while that person is alive, if anything is owned by that trust, it's still the person's social security number. It's still, I can sell it, move it, change it, do whatever I want. But when I die, it's not in probate court. So trusts are a beautiful, beautiful thing for the people who need them. Not everyone needs them. For example, I have a daughter who's like 33. She's married, no kids. She rents an apartment. So she has no real estate she has to pass on. She just can put a beneficiary on something and she doesn't need a trust. You know, but people who own more or have children, then trusts make a lot of sense. I usually think if someone owns real estate or has children, those are two good reasons for a trust. If someone has a special needs beneficiary, it could be a nephew, that's another good reason for a trust. Okay, so trusts are invisible, but I try to make them visible. I try to have an image. So my image is a box with a design on it. And I used to bring these boxes to the seminars, but then with Zoom, I decided to take pictures and put them up here. So when I was taking the picture, my cat wanted to be in the picture. So he is very interested. And this says parents trust while parent is living on earth. So this, we're setting up, let's say this is Jose. Jose's is a parent, and Jose, or he doesn't have to be a parent, he'd just be an adult who wants to set up a trust and leave things to someone. This is his trust while he's alive, and he can be the trustee, the beneficiary, the person who put the money in. He's everything. And it doesn't have to really impact his life at this point. It's getting things set up so if he dies or he's unable to think straight, we call that incapacitated, things are in place the way he wants it. He gets to say how he wants it instead of just leaving it up to a judge to figure out and take a lot of time and money. So that's that initial trust. But we're going to show this example, we're going to pretend we have a parent here. So then, and we're going to pretend right now that that person was married. So when that person died, then the document, so the document the attorney writes is the instruction manual that goes along with that trust. And the instruction manual can be changed over time if Jose wants to. Now, and that trust can say that, okay, if I die before my spouse, we're going to have this trust for my spouse. And then after my spouse dies, we're going to have these trusts for the children. So the instruction manual can cover all these trusts that could come from that initial trust. So this one is after let's say the husband dies and we have a trust for the wife. And then after the wife dies, we're going to assume they have two children, a son and a daughter. Then half can pour into the parents' trust for the daughter and her descendants, and half can pour into the trust for the son and that person's descendants. And if the person writing the trust says to the attorney, yes, these people are financially responsible, I want them each to be in charge, then the daughter can be in charge of what's in her trust, the son can be in charge of what's in his trust. If you had any concern that, well, no, this person isn't good with money or something, you can have someone else be the trustee. Any questions so far? Because this is important about trusts. Anything you want to talk about?
I understand with trust, items have to be itemized and listed. And if you sell or dispose of something that's listed on the trust without changing the legal document, that can cause a problem.
Well, That's an interesting question. So Lizzie's told me I need to repeat questions so the people online know what you asked. So let me see if I can repeat it and you tell me if I repeated it accurately, okay? So your understanding is that if a person set up a trust, they need to itemize what is owned by this trust. And then if they took something and moved it or did something else with it, they have to keep track of these records.
Right, might say a couple of valuable things,
Paintings, okay,
just as an example.
okay. All right, so did I repeat the question?
Yes.
Okay, good. All right, now there are probably in the Chicagoland area, there's probably 200 or so attorneys who do estate planning. Good attorneys who focus on estate planning, and each attorney might do things a little bit differently. So the answer I'm going to give you is the way I do it. Okay. This is how I do it. And I think probably at least 90% of the attorneys I know would do it this way. Okay. You might have met an attorney who does things slightly differently. But this is how I think many of us do it, is at least this is how I do it. I'll tell you how I do it. Okay. If someone has a trust, not every person I talk to needs a trust, but let's say a person does need a trust. We talk about it, we think about it, we say, yeah, that's a good idea to have a trust. Then I put a page at the back of the trust, which is an assignment of personal property to the trust. And they sign that. So now on the day they sign their trust, now their furniture, their artwork, their jewelry, their fishing tackle, whatever, it's called tangible, things you can touch. It's all owned by that trust just by signing that page, and that keeps it out of probate court. Then up in the trust on about page 2, I have almost a full page about tangible personal property that doesn't need to name anything specifically, but it says in the first 2 paragraphs, it says, if I want to, and everything's written in first person as if it's the person writing the trust. If I want to, over time, I can create a list and say that certain items go to whoever I say. And then the next paragraph says, I can change my mind over time. And when I die and they look at these pages, they should honor the one that's most recent if they conflict. And then the third paragraph says, if there's something I haven't put on any list, then this is who I want to figure it out. Like, for example, if people have children, they might say, I just want my children to figure it out, take it. Or if they don't have children, they say, I have this list of beneficiaries here. I want these 5 people to figure it out. So when I help a person write a trust, I don't require any list of what is owned by the trust. I have that assignment at the back that covers artwork and everything. Then if the person wants on their own to say, this painting over here, and describe it well enough so we know which painting we're talking about, they put that on a separate piece of paper and they date and sign it. They can put as many items as they want on that. This painting goes to so-and-so, this painting goes here, this fishing tackle goes here, if they want to. And then over time, they can just keep changing their mind. They don't have to come back to me. They don't have to tell me, but they want to keep those pages with the documents. So if they die, their trustee, whoever they've named as the next trustee, can find them. I have had situations where people say, this diamond ring has been passed down for generation after generation to the oldest daughter. And Deborah, I want a paragraph about that ring in the trust, and I want a picture of it, and I want it there. So if it's that important and you're not going to change your mind, fine. I'll write a paragraph, put a picture, describe it, do all sorts of things. But for most people, they don't need me to put it in the trust document. I have seen some trusts that some attorneys help people with where they list, I'm going to put this account in the trust and blah, blah, blah. I don't do that in my trust documents, but when I work with people, I work with them and coordinate with them about, okay, what do you plan to do here for we know your IRA or your 401k has to stay in your own name, and who do you want as the beneficiary? Do you want your trust as the beneficiary? You want your spouse? You want your children? Who do you want as beneficiary? Now for your if a person has an investment account that's not a qualified retirement plan, just a plain old taxable stocks and bonds investment account, for that, the trust, if a person had a trust, the trust could be a beneficiary. Or the trust could own it during life. But I don't say that in the trust document. That is done like with the investment advisor. And then if the person says, oh, I was with this investment advisor, I want to change, I want to go over here, I want to move it over here, just keep doing it, but you can have it either owned by the trust or the trust be a beneficiary, or you might want others to be beneficiaries. But you might have a setup on your trust that says already in the trust attached, this painting goes to so-and-so. And if you don't want the painting to go to them, you might have to actually change something. But I haven't seen attorneys do it that way, but maybe you have the one where it's done that way. Any other questions while we're right here? Because we're close to the end of what I want to tell you. And I really encourage questions and discussions. So anything else to talk about, or anyone online or here have any thoughts you want to bring up? Okay, well, I'll go to the next slide. You're always welcome to ask questions, or I can stay afterwards if you want. Here's a new thought I haven't told you yet. If assets remain in trust after death, you can protect the people you love from their potential creditors. And suppose we went back to the idea that someone had a son and a daughter, and you say, well, I think they pay their credit cards every month. I don't think they owe anybody. But any of us could, without meaning to, be in a bad car accident. So we all want to have really good car insurance. And so sometimes there can be an accident where the judgment against a person is more than their insurance covers. So if we had it like we had back here, if like the daughters, if what that parent left the daughter and her descendants was in that trust, even if she's in charge of it, we can protect that. So if there was ever a judgment for a bad car accident or some other reason against her, they should not be able to take this money that the parent left her. And if she got married and later divorced, this also helps make it more clear that, okay, that's off the table. We're not dividing that in divorce. So the combination of this picture with the text on the next slide here, when assets remain in trust after death, you can protect your descendants or other recipients from their potential creditors. That parent I was talking to before I created, a trust for son and daughter might have said, oh, just give it to the kids, let them do whatever they want with it. And then I explained, okay, well, you can sort of do that, but if you leave it in a trust that each one can be in charge of, you're giving them this asset protection that they can't do for themselves. So that's what this slide is about. And then I'm going to hope you all have some questions or things you want to talk about. But I'm going to show you, this is a picture of my family and grandkids on a river in Wisconsin. We love to be on rivers. And then I'm going to show you in blue, we started with these words. They were a different color when we started it. They're so important. I want to just repeat it. To avoid the probate court process, every account that's not owned in trust needs a beneficiary, including bank accounts. Beneficiaries can be individuals, charities, or trusts. That's a really important to know. And then I'm going to show you this picture that some of you have in front of you. I took that at the botanical garden. And for those of you online, or even here, my website is debanthony.com. And if you have any questions, you can let me know. Also, I'm happy to answer questions here, or if we wrap up and anyone individually wants to ask a question, or people online, this is your chance. Everything super clear?
It was very clear. Deborah, I have a lot of ideas for myself.
Okay. get those beneficiary forms. I saw my son today, who's about 41. He's married with 3 kids and he has a trust, but he needs to change his beneficiary designation on his life insurance to the trust. So I saw him today and we were talking about, he lives in another state and I was going to visit him for Thanksgiving. He was saying, you know, if I have time, I'll look for a rental car for you. And I'm like, you know what, if you have time, could you change that beneficiary on your life insurance to your trust? Because we've only been doing this for about a year. Like, you know, like there's fun things to do, but could you just get the beneficiary changed?
What would a typical attorney charge for helping, say, a husband and wife set up a trust for their family?
What would be the charge? And so if the attorney was doing that, they would probably not just do the trust, they would do the wills, they would do the power of attorney forms, and they would do real estate documents that relate to that. So that is a fascinating question because many attorneys are, you know, make their own decisions about what they're going to charge, and the range of what people charge can be a big range. But just to throw out sort of what I think financial advisors around here probably tell their clients that it would charge is, if you were thinking maybe 2,500, something like that. There are people I've met who've paid 100,000 in Chicago. There are people I know in Naperville who charge a minimum of 10,000. I mean, there's a big wide range. And then you would want someone who knows what they're doing. So as I mentioned, there's probably 200 good estate planning attorneys in the Chicagoland area, but you don't want to just go to someone who does other kinds of law. And the story I mentioned to you with the man who got the will with the, you know, he didn't have kids and you had to do the genealogy search, that attorney did not do that man any favors. You know, so it's very hard for, once I used to work in a corporation and we were merging and we needed a new computer system and we were interviewing different people to set up the software. And I'm sitting in this, you know, corporate boardroom and I'm like, how do I know from their little song and dance if this software system is going to work? So it is hard when you're not an expert in that field to know if the person who's talking to you is going to do it right and it's going to work for the long run. But I think one of the things is in school, you know, there are some people get A's and some people get C's, and I see that in the legal field. You know, there are some attorneys who have excelled and there are some are just like, give me the money and who cares? So there's a range, and I try to be a person who does things in an excellent way and study. And also I try to make it easy, try to bring it hopefully to where you caught the message, I hope. And if you didn't, ask me for follow-up.
I've got a Zoom question. Can you describe the best legal vehicles and beneficiaries to minimize state and federal estate taxes?
Okay, so that's a great question. I did not yet talk about estate tax, but we could talk about that because that's important. There's both state estate tax in Illinois. Not every state has a state tax. And then there's a federal estate tax. In other words, those are death taxes. It's like an extra tax. The federal number at the moment is over 12 million. So a person could die with up to 12 million. And in the state number is 4 million. So in this area, like even my son who's young, he probably has 2 million in life insurance. You know, he can easily, there are people, I have another son who probably has 3 million in life insurance. You know, you can easily, you don't have that money to spend in your pocket to buy groceries, but if you die, you got millions. So especially with young people with life insurance, that counts to qualified retirement plans. the market value of the real estate. A person might have bought the house for one price, but at the time they die, it's worth something else. That counts. So most of the time, if someone's married, we're not going to have a death tax when the first spouse dies, because there's if you leave things to your surviving spouse, there's an unlimited amount that can be deducted there. So usually we're concerned about a possible death tax when the second spouse dies. If together, they would be over 4 million in Illinois. And the surviving spouse stays in Illinois and dies in Illinois. So one of the things about the trust, I mean, I have a lot of clients that are over 4 million if you add in the life insurance and so forth. By having a trust for the spouse, when we go back to that picture, let's go back to the trust for the spouse. That picture, if I can get back to it. This one, family trust for the spouse and descendants. That is also a credit shelter trust. So if like the husband dies and leaves some assets there, up to 4 million in Illinois and possibly more in a trust that counts for federal, then when the spouse dies later, those aren't counted on her list, even though she can be in charge of that and that's for her. So you can get 8 million, you can get twice as much free of death tax by using trust. And then if people have life insurance, we can, with a different kind of trust, we can get that totally off the list for either of the spouses when they die. That's what my oldest son has done. I helped him with, I think, 3, they're called irrevocable trusts. So for example, his wife becomes the trustee of the one on his life insurance. He becomes the trustee of the one on her life insurance. You can't be the trustee for yourself for an irrevocable trust, but it keeps it out of being counted for death tax. And then he says to me, Mom, why doesn't everybody do this? I'm like, they don't all have a mother who does it for free. So as people go up, like some of the attorneys in Chicago who are charging probably $2,000 an hour or so, they're dealing with people with over 500 million. I mean, they don't want to talk to anybody less than that. There's like strata of which attorneys want to talk with people in what levels. There's certain attorneys who only want billionaires. I got invited to join a firm like that. And then I thought, I didn't go to law school so that no billionaire ever has to pay a penny of tax. It just, I'll let them do it, let some other attorney do it, but it's just not, it doesn't motivate me. But there are all these shenanigans that when you get above 25 million in assets, there's what I call shenanigans. There's all these shenanigans to make it look like the money disappeared so that people who are super, super millions and billions don't ever have to pay any tax. But that's not the game I play. I'm just not interested in playing that game. But I do go to a lot of seminars that the attorneys who work in that strata teach, and I learn a lot of good things that help my people who are usually up to about 15 million, which covers a lot of people around here. More things to talk about.
Are there any resources you get, like, I know my wife and I are in the process, we want to choose an attorney to help with
Right.
estate planning. Is there any resources to like help? I mean, I'm impressed with you and I
Right.
certainly consider that, but is there anybody that just like rates attorneys in some way, or how would you go about identifying somebody who's
Super good.
or good?
Well, there are these groups called estate planning councils. There's one in DuPage and there's one in Chicago. I belong to both of those. The one in Chicago has about 700 members that are not just attorneys, they're financial planners and accountants. Sometimes talking to an accountant or a financial planner, if you know someone you think is a good accountant or financial planner, they might, like, for example, I've had like somebody uses a certain financial planner and then that financial planner wants to interview me to know if I know what I need to know. So the financial planner may not necessarily have a list of people, but that financial planner might be able to interview the few attorneys to say, hey, do you know about this, that, and the other? I noticed she has some books on the back about estate planning. One thing I do that I don't think most other attorneys do, but I give people a free up to 2-hour meeting with no obligation. And we go over everything. And also, if people already had a trust, I'll look through it and evaluate. This is more fun for me than playing a board game. So, you know, I don't charge for a lot of things. And then if people want to work with me and we come up with a plan, I have a flat rate. I know there are other attorneys, as I say, in Chicago, they're probably charging $1,000 an hour, $2,000 an hour, but some of those people are saving people $8 million in what they would pay the government, you know, so they're playing with bigger numbers.
Do you have an office or are you located in?
I'm in LaGrange and I travel and I have meetings by phone or other ways. So, and evenings, weekends. So I really love this. And, you know, I try to keep up on everything I need to know. The laws are always changing. Illinois had a big trust code, 400 pages come in 2020. And the laws related to IRAs also changed in 2020. So we had, you know, a lot of things changing in 2020. So there's always more to learn.
I have another Zoom question. Somebody just want a clarification. Is a trust for like the family broadly, or would you recommend one trust per family member?
Okay, so it, I just need a sip of water, just a second. There we go. I'm sure I brought it. Illinois is a separate property state. Unlike California, which is a community property state. So here the best price is to do a trust for the husband, a trust for the wife, or a trust for each spouse. I think that's the best practice. And it doesn't really cost more than sharing a trust. And it might be, for many people, nothing's going to this trust until the second spouse dies. So we're probably not going to use one of the trusts ever, but we don't know which one we're not going to use. So if we write 2 of them, then we're ready for whatever happens. Anything else to talk about? Well, it's great to be with you.
Definitely. Thank you so much.
You're welcome.